To secure the securities, bankers use different modes of charges: pledge, hypothecation, mortgage, assignment. During the ordinary course of banking business, in addition to these, the terms like lien, set-off also assumes importance. The nature of security could be classified into different types of assets: movable, immovable, others. Intangible assets also gaining importance. Fixed assets, floating assets. Pledge, bailment of goods for purpose of providing security for payment of debt or performance or promise. That is Section 172 of the Indian Contract Act. Bailment of goods essential, delivery of goods essential. Bailment must be by or on behalf of the debtor for the purpose of providing security for the payment of debt or performance of promise. Pawnor, pledgor. Pawnee, pledgee. Generally, borrower is the pawnor or the pledgor who pledges his asset as security to the banker. Creditor who lends on the security, banker is considered as the pledgee. The agreement is pledge agreement. Transaction, pledge transaction. Security has to be in the form of movable. Ownership, pledgor. Possession, pledgee. Right, pledgee. Loan on the security of life policy, national savings certificate, shares, term deposit, receipts of bank, gold ornaments. Actual possession, constructive possession, symbolic. Third party pledge, possible. The asset belongs to the third party pledgor, and on the strength of that security, creditor, pledgee, lends to the borrower, debtor. Document include third party pledge agreement by the owner of the asset given as security under the pledge. Demand promissory note from the actual borrower to bind him personally for the repayment of the debt. Pledge possible, constructive delivery, no physical transfer of goods from the custody of the pledger to the pledgee by handing over the keys of the godown in which the goods are stored or kept. Goods are in public warehouse, handing over the documents of title to goods, RR, LR, BL, warehouse receipt. When goods are delivered physically, actual. When key of the godown handed over, symbolic. Existing goods, not possible for future goods. Goods must be specific and identified. Possession is very important. If possession is lost, pledge is lost. Agreement in writing without any ambiguity. By owner of the goods, mercantile agent, person in possession of the goods under a voidable contract, as the case may be. The pledgee acts in good faith and has no notice at the time of pledge that the pledger has no authority to pledge. This is very, very significant. Goods which are existing, future goods, both A as well as B, none. Pledge cannot be created in the case of goods which are existing, future goods, both as well as future goods, it is not possible. Existing goods, it is possible. Seller of the goods who continues to be in possession of the goods even after sale can create a valid pledge. Pledgee to act in good faith and without notice of the previous sale. Right of retainer for non-payment of the debt, interest, both, non-performance of the property, and for all expenses incurred to protect the goods pledged. To protect the goods pledged, right to claim extraordinary expenses. Lien over the goods cannot be claimed but can sue for recovery of goods. No right to retain in respect of the other debts. In the absence of a contract to the contrary, the pledgee, pawnee cannot retain the goods for a debt or promise other than the promise of debt for which they are pledged. So it is applicable to a particular transaction alone unless otherwise it is agreed upon. Rights against third parties. If the pledgee is deprived of his goods, he would have the same rights that of the owner of the goods against third parties, decided in a case against Union of India. Pledge's right, where pledger makes default in payment, he may sue the pledger upon the debt or promise. He may retain the pledged goods as collateral security, or he may sell it after giving the pledger reasonable notice about the sale. The pledger's duty: disclose to the pledgee any matter or material facts or extraordinary risks. Failure to disclose makes him, the pledger, responsible for damages, must reimburse to the pledgee the expenses incurred to protect the interests of the pledged goods. Under a forced sale, the amount realized is less than the debt due. Pledger must make good the loss or make good the balance. Goods are pledged, implied condition that the pledger has title to goods pledged. That means he has the right. The pledgee is for the goods delivered and upon all documents of title to goods deposited by the pledger. A declaration that the existing securities deposited would cover the existing and future debt, interest and expenses. The letter stipulates that it will be a continuing security without the operation of the rule in Clayton's case. Valid pledge possible by endorsement of railway receipts. Delivery not required. Constructive delivery is sufficient. Banker is entitled to recover the value of goods from railway as a pledgee. Under pledge transaction, the borrower was advanced money by the banker pledgee. Security different varieties of sugar in bags. For the due, state government seized the bags of sugar and sold them to recover. Bank filed a case against the government. Bank's right as a pawnee cannot be taken away by the government, and state government was advised to pay the amount due to the bank. Banker as a pledgee had the sugar bag given as security. In a decided case, this has been decided. During the pledge transaction, the pledgee bank received additional shares as bonus along with dividend on the pledged shares. The pledger claimed them, the bank retained them. Supreme Court observed the pledgee to return them to the pledger only when the pledged goods assets were returned. In case the pledger defaults repayment on the pledge transaction, the pledgee has the right to sell the pledged property along with accretions. A reasonable notice is essential and must. The term pledge beyond the purview of registration of charges in respect of company assets given as security to obtain finance. Same is applicable as far as SARFAESI, Securitization Act, is also concerned. The term hypothecation is not discussed in the Transfer of Property Act, Contract Act, Sale of Goods Act, all of these. There has been a mention made in the SARFAESI Act, that is Securitization Act only. Hypothecation, ownership, possession, right, it has been already discussed. First time the term hypothecation found a mention in SARFAESI Act 2002. A charge in or upon any movable property, existing or future, created by the borrower in favor of a secured creditor without delivery for a financial support. If a manufacturer is manufacturing, he requires the raw material, semi-finished goods, finished goods to complete manufacturing. In such cases, the appropriate security would be hypothecation of stock. If a person is getting a vehicle, he has to have the possession, otherwise purpose is defeated. That is the reason hypothecation is applicable in the case of movable property like vehicle also taken as security. Floating charge, any crystallization of such charge into fixed charge on movable property. The charge and movable assets could be by hypothecation. For vehicle finance, hypothecation is a must. For working capital, hypothecation is more appropriate than pledge. The difference between pledge and hypothecation is mentioned here. Have a look at it. It will give an idea about the difference between the two. Again, the difference between hypothecation and mortgage is available. The extension of hypothecation for a immovable property is generally called as mortgage. In both the cases, possession is generally with the owner or the borrower, and the right is with the creditor, and the ownership remains with the owner, that is the borrower. In the case of hypothecation, applicable for movable property, mortgage applicable for immovable property. Stock statements, when manufacturing is involved, the goods are going to be under the possession of the borrower, manufacturer. It is left with them under trust, belief. So, to understand and check whether the goods are available, they are being manufactured or being sold at regular intervals, stock statements are required to be got, and the decision has to be taken, and they will have to conduct inspection at irregular intervals. There has to be appropriate full value insurance to cover the stocks kept as security. If the borrower is involved in over trading, the banker experiences that the number of checks issued or returned with the reason exceeds the arrangement, delay in submission of stock statement and other associated data, slow or reduced sales, all could lead to non-recovery of funds despite goods are hypothecated. When security is there, that gives support. That alone will not bring the recovery. The banker has to be more careful in monitoring the accounts on a regular basis without exception. Hypothecation agreement properly filled in, duly signed by the executants. It has to be duly stamped. For limited company, finance and hypothecation, charge registration has to be done. All details relevant to protect the interests of the bank to be incorporated in the agreement. These are the things which should appear in the agreement to protect the interests of the bank. Which one is more appropriate when the goods in process has been considered as one of the securities by the lending banker? Hypothecation, assignment, pledge, lien. The appropriate answer is hypothecation because the goods are to be in the possession of the borrower. Whenever charge is there, the banker should understand the reason for such a charge, and they will have to see that whatever the protection required, that is to be taken care of. The knowledge about the contents of the respective agreements very much essential for the lender to understand the implications as far as the banker is concerned. The casual approach by the lending bankers have costing them heavily. To avoid unpleasant situation later on, it would be advisable and prudent for the banker lender to be very careful in understanding the contents and ensuring proper filling up of the appropriate column with relevant details without fail to avoid complications at a later stage. Even though most of the bankers are experienced, still there are cases where bankers are facing problems on account of these developments. A person is having both savings bank account and a current account. The savings bank account is showing a balance of 7,654 credit balance, whereas the current account showing a debit balance of 867 rupees. Banker owes the money in respect of current account. Banker has to get the money for savings bank account. In both the cases, the relationship remains the same. In both the cases, the relationship not same. That is the answer. In the case of first one, the banker has to get. The second one, banker is owing. So the last answer is the appropriate one. Right. Let us have some at random, some questions to understand the answers. Which statement is inappropriate in respect of security charge? Hypothecation portion is not with the creditor. Pledge portion is with the lender creditor. Pledge ownership is transferred to the lender creditor. Hypothecation ownership remains with the owner. In the case of hypothecation, portion is not with the creditor is correct. Pledge portion is with the lender creditor is correct. Hypothecation ownership remains with the owner is correct. Pledge ownership is transferred to the lender is not correct. Ownership remains with the owner in all the cases of charges created. So that is the answer. That is C is the appropriate answer in this case. The car loan has been provided. The borrower, after paying 3 installments, stopped paying the further amount. Bank has to keep quiet. Bank has to initiate steps for recovery. Bank has to treat the account as NPA and report to the concerned authorities. Bank has to give further time for repayment. B is the appropriate answer because there has been a default in repayment.